If you are preparing to file an immigration application or petition with USCIS, there is an important policy update you need to understand. USCIS has clarified its policy concerning requests for evidence, known as RFEs, and notices of intent to deny, or NOIDs. And here is the part applicants need to pay close attention to. You should not assume that USCIS will always give you an opportunity to correct missing initial evidence before denying your case. In this video, we'll explain what changed, what an RFE and NOID actually mean, and what you should do differently when preparing your immigration filing. Let's start with the basics. A request for evidence, or RFE, is a notice from USCIS asking an applicant or petitioner to provide additional evidence needed to determine eligibility. An RFE does not automatically mean your case is going to be denied. It means USCIS is requesting additional information or documentation before making a decision. For example, depending on the type of immigration benefit involved, USCIS may need additional evidence to establish eligibility or clarify information already submitted. But there is an important distinction under the updated guidance. An applicant should not treat an RFE as an automatic safety net for an incomplete filing. If you want clear explanations of important U.S. immigration and legal updates, subscribe to our YouTube channel and turn on notifications so you don't miss our next video. A notice of intent to deny, or NOID, is different. A NOID generally tells the applicant or petitioner that USCIS is considering denying the case. It identifies the basis for the proposed denial, giving the person an opportunity to respond. The important point is that neither an RFE nor a NOID should be ignored. If USCIS sends you one, the response needs to directly address what the agency is asking for or the concerns identified in the notice. Deadlines matter. And a weak, incomplete, or poorly organized response can put an otherwise viable case at risk. Filing an incomplete application can be a risky strategy. Now, let's get to the major point of the update. USCIS has clarified that requesters are expected to establish eligibility when they file. Under the updated policy, if a benefit requester fails to provide required initial evidence when filing, USCIS may deny the request without first issuing an RFE or NOID. That is extremely important. It means applicants should not assume that USCIS will always send a notice giving them a second opportunity to submit something. Now, there is an important clarification. This policy does not mean RFEs and NOIDs have disappeared. USCIS can still issue them when appropriate. The key change is that applicants should no longer assume a notice will come first. The burden remains on you to establish eligibility for the benefit requested. So, what should immigration applicants take away from this? First, do not rush your filing. Second, review the form instructions and identify every piece of evidence. Third, make sure the evidence supports eligibility. Fourth, keep organized copies. And finally, if USCIS sends an RFE, do not ignore it. Take it seriously. We understand that immigration filings are more than forms. Behind every application is a person, a family, a career, or a future you are building in the United States. If you are concerned about your case, do not leave your future to chance. Contact Maduabum Law Firm LLC at 973-732-1490 or visit maduabumlaw.com. Remember, immigration policies can change, and every case is different. For advice about your specific circumstances, speak with a qualified immigration attorney.